Etiefo me mo bibia akwaba eba Melodies TV so. Ende ebe yere pa na title sorry about responding or the response about. For people who don't know title sorry Alban Bagbin a lawyer ati ase ono na embra afenyumakin edi asem ekokodan that time no Madam Torkornoo enim no title sorry ati ase, and we saw the up and down between him and then the Chief Justice and all that. Na odensema baba betuja na ohwe de okan she said we see not as a many allegations we making no title sorry man a response. Now the first one I said the Honorable Learned Chief Justice of several years standing at the bar. The Honorable Learned Chief Justice of several years standing at the bar, judge for so many years, says the Article 146 proceedings against her ripple far beyond her as a person. I say Chief Justice no, why lawyer for so many years. Uni memra, was also a judge for so many years. I say, sa Article 146 na ye AD no. E ya die bia, I say, a brone so. It ripples far beyond her. In the sense say, enyo no pe, and I say, ubenya nsusu aso no. In the sense say yanhwe ye ni yan stop sa ade we ya. E chirimba. Ebia aban foforo ba wo de beye nkrofo foforo. Iti ma menen nsem a wo kan no. Say it ripples far beyond her. Ye di dina ye besan so de akwa akodi obi foforo, ye de beye obi foforo yanhwe ni ye ya institution of independent institutions e wo krom ha ni na no. Aban be yi omo through Article 146. Iti ho ena Tado sorry a responded say we say Ghanaians need no education on it. Osi Ghana for enye won na obeba betre education so. Charlotte say and other justices of the Superior Courts have been subjected to it, and there is too much case law. Osi enye won na obeka asem we atre Ghana for. The same article ni di Charlotte say. Other Supreme Court judges the same article we eni di yomo. Inti won to me mama mekasa te say de eye wope eye first time na ade we si na ya hwe ni ye ni an stop ya ebeto obi foforo dabi omudi yi Charlotte say na yeti krom ha bibia nsi ye di Supreme Court judges bibia nsi under His Excellency John Dramani Mahama the first time ye di Miss Lamte bibia nsi inti di enta na wakasa te say eye new thing. 2. She said she applied for a public hearing of Article 146 proceedings. We ask, how could a whole justice not know that? 1. The Supreme Court has, in at least 3 cases, affirmed that Article 146 proceedings must be held in camera. See the cases of Justice Derry versus Tiger IPI 2015-2016. 2. SCGLR 812. Ajay Chum versus Attorney General 2005-2006. SCGLR 732 and Ghana Bar Association versus Attorney General 1995-96. 1 GLR 656. O say asemwa wo kan. O say wo apply say Article 146 in yatro wo mra nimu say me yemfa ma abonten na so wo apply say yenye na abonten na Ghana phone ni ehu yen telecasting na live na Ghana phone ni ehu. And I watch say now who name say Supreme Court kra na wote na no in 3 different cases. Omo ama ruling was same way so that say Article 146 no mayen ka ho asem any kwansi ye de ba abonten. And the obo cases no say Justice Derry any Tiger IPI only anas case be a course so 2015-2016. Supreme Court asem omo kan no. Mayen ma case name ba abonten mo obi enhu. Another case in 2005 and 2006, Ajay Chum, Supreme Court Ekan. Another case, Attorney General 1995-96, Supreme Court Emasa decision. It's 3 different cases, Supreme Court Emasa decision say Article 146 ni ye di obia, any kwan say ye mo obiate. It is a wo obi a na wo ye Chief Justice esanso Supreme Court ona send ye di do na wo ba abonti abeka say wo de wo pese omo obi tia eno no ye nte wase. Is it because you are a special person ye dia ye obi ba wo de man ye fa anya wo de 2. All previous Article 146 proceedings which were conducted under the auspices of Chief Justices have, in accordance with the Constitution and the Supreme Court decisions, been held in camera. Or say, all previous Article 146 proceedings which were conducted under the auspices of Chief Justices have, in accordance with the Constitution and the Supreme Court decisions, been held in camera. Into Obisa, say, Krom Hagana yeti, sa Article 146 no, ye de are nkrofo bebre. Ye de yin nkrofo bebre fi office. Obisa say, which one of them? Any ye penny soma Ghana for ehun ye. Which one of them? Because nini na they were held in camera. Because the Constitution has been clear. The Constitution has always been clear on it. And why are you doing this? Didn't you know yes I did way? I said yeah. Obia enra. It goes to the point I was saying. How did she become the Chief Justice? Because yesterday she spoke as someone who is not having all these years of experiences in Mrane Nyamano. Seriously. Now, the third point. I say, is the Chief Justice complaining about the striking out of her supplementary affidavit by the Supreme Court in a suit by which she herself invoked the original jurisdiction of the Supreme Court? Obisa say one kasa and I the Assembly Court Supreme Court. One kasa and I invoke the original jurisdiction of the Supreme Court. Ewo case we so. Supreme Court na bo wasemegu. Afei o complaini say Supreme Court abo wasemegu ana. One kasa won semo a wo de akwakodan Supreme Court a Supreme Court abo egu no. Wa wo complaini. Inti answer nini. We say, has the Chief Justice so soon forgotten that in one of the LGBTQ plus cases, she ordered that the affidavits of Wendy Yeboah, who deposed to an affidavit on behalf of the Right Honorable Speaker of Parliament, be struck out, even though she could not point out one paragraph in it which was offensive. How come the Chief Justice does not know that she was in the Supreme Court invoking its original jurisdiction, but not to enforce her fundamental human rights, in respect of which it is the High Court which has exclusive original jurisdiction? Question I will be sir, Chief Justice no. Very simple. I'm going to explain so you understand. I say, one kasa na odi asem na ko Supreme Court. Supreme Court abo wasem egu. Ende usu. Ende wu complaini. Ure fi hu say LGBT killings and semo e bae. Lady bi a na ye frɛ no Wendy Yeboah. Ede ensem baya no waka say Alban Bagbin ensem a wono nso aba be dan Supreme Court on the LGBT ensem do, but Alban Bagbin ensem gu. I say, has the Chief Justice so soon forgotten that in one of the LGBTQ plus cases, she ordered that the affidavit of Wendy Yeboah, who deposed to an affidavit on behalf of the Right Honorable Speaker, be struck out, even though she could not point out one paragraph in it which was offensive? Into one kasa Alban Bagbin nsem bia wo de ba LGBT case no. Alban Bagbin nsem bia ba beto wanim. E was Supreme Court no. O ma order say yembongu. Has the Chief Justice so soon forgotten that in one of the cases she ordered that the affidavit of Wendy Yeboah, who deposed to an affidavit on behalf of the Right Honorable Speaker of Parliament, be struck out, even though she could not point out one paragraph in it which was offensive? LGBT killings and sem Alban Bagbin and sem. there was a lady be affidavit be when the yeboa Alban Bagbin case nearby no. Oh my order say yembungu. But oh dear yabo egu no. Oh complaining. But now watch Supreme Court on as the Chief Justice. Oh dear now bonk for the egu. And they will be complaining. That's the first point. The second point, I say, how come the Chief Justice does not know that she was in the Supreme Court invoking its original jurisdiction, but not to enforce her fundamental human rights, in respect of which it is the High Court which has exclusive original jurisdiction? Ghana has say, say eba High Court in say eba human rights in sense one yemfanko Supreme Court, ye de call High Court. Into I say, now ye Chief Justice. Unim say human rights in sensem ye de kwa High Court ni emfanko Supreme Court. In some way what can I say? Committee in India or more no, they are infringing upon your human rights. Now so upeja asem no Supreme Court now they asem no call ye now so one fan call High Court. Me wa Ghana mratre say human rights in sensem bia no High Court in Indi. Inti obi now ye Chief Justice na wu nim sa mrana na wu nim ana. I hope you understand what Tadosori is saying. Point I will make it. Now saying Obi Bekatre me say, and you see sometimes people, let me just mamifa we infame Obi Betro comment be or comment na say it was funny. Unse eto de bia the reason why I explain things like this ne say me pese obi a wotie me bia etiase. Enyo obi a na sebe in legal matters like this no and then you be an Ghana and sensem no ye kind of bluff money nyama or tiasie kra papa sa that yase and you be an etisa obi be catch say to de be a send ya me trend nsem ase no as de me dim crofo atem because ade no wo tiasie now so me tre nsem a me kasa te say as de omo ye nkola bi no mutie me. It's funny sometimes obi to me catch me say melodies who to me tre mu ma me tiasie ye enye wo na wo tre nsem na ase a na nka me ntiasie. But obi nso tre say me tre mu ma ne ko form dodo as me di omo atem say omo ye nkola omo tiasie de dan no me movie on na me nka me read keke na me nka iti we are me tre mu say no na what tiasie. I want every single person to get it. If I am able to read, and some of the things I'm reading it several times. If I'm able to read and you understand the first reading, God bless you. But se me readi biom na me sanso tretre mu biom na ebia wo bia wan tiase ono nso beti ase a it's not something you need to be at ase. It's not any hard feeling. Enya ade bia wo say o complaining about kra at ase. Nini na ye person obi at ase. It's as simple as that. Into what's it tad or sorry in some walker. First, what he wants to say, and they say, "Oh, complaining say ya born semgu, oh now born microphone semgu." Na ya bo would you no complaining. Also see human rights. Who him say human rights as a High Court in the court. The India now they are Supreme Court. Basically, that's what I sorry is saying. The fourth point: did she say her rights were violated? That the committee did not point her to the specific allegations in respect of which a prima facie case was made. It was say, "Ma'am, no press conference no." Or some they can say you are violating a right. Committee no motenase no. Omo antren no bone kra wo no kredi. Omo antren the petitions. Ye dia ba ye dia tia na tese ono kra no committee na wakwakwate na enim no. Onim de okoye wo. Basically maame na asem no oka no. You see, me say enra na me tie maame no. I'll go back to it. All I was saying was, how did she become a Chief Justice? Because that's one of the things she said. In semni binu no committee na wako enim ne krane onim asem a ye raise etia no obi a wo request from the president say nsem a ye page etia wo no won fa maw a wo no de amaw e na enam sa asem ne so e na wo de response by e nam so ntia wo akọ committee enim no wo se committee na ya fro no unim asem a ye page etia wo But I sorry in some more canny. But see, we ask, to what allegations did she provide her responses to enable the prima facie determination to be made? As simple. Or say, uni mean some more APJ. In some ben response ben, and our trauma president no. Because my president no response. The response ben our trauma president na. president Nico consulted with Council of State, I will find a prima facie case against you, no, and no a response by because who name asem na not just saying why be na woman. Simple answer. Simple. 5. Did she say the committee decided not to force Daniel Ofori to testify? Our answer. So our Chief Justice does not even know that the law is that a party is not obliged to testify. See the cases of Nyame versus Ansa, 1989 to 90. 2. GLR 152CA and RE Ashaliboche 2003 to 2004. 1. GLR 420. I say Obabe complained said Daniel Ofori. One of the petitioners no. Committee no. Amma Daniel Ofori. Amma me testify. Wama me jine nim. Amma me trese. And say ni say. I say oh. I say we ye mbra. I say who ye Chief Justice na who ni mana. Say a party is not obliged to testify. And you see, it's funny, unim dentia. That was the same Emra wa modere Ghana for Emra na Jemensa, the election petition no 2020. Omo ama Jemensa want testify, which Chief Justice we no yet part of the panel. Emra na wama Jemensa testify na Chachuchi kata ekatro mo say de wudia no eno ana wutwa no and they won't say wutwa. And they won't say Chachuchi kata asem no kan wutwa. Won't say aduaba ye maami dua ye. And they won't say wutwa. Because we see nipa kra wo raise petition etia Daniel Ofori no. O say one man be testify. O say enu hunti. Committee na edwuma mo ye no enye edwuma pa. E na ye ka kra say eye Ghana mra. Intia na modere Ghana for mo amma Jinmen Samba be testify because enya by force so obi be ba be testify wo power be ye wo power nye. Intia Daniel Ofori say me raise issues etia me man be testify o say enye mra. But Ghana mra. And the real one there, hey. 6. I say, and she said her husband was not allowed to be present during the Article 146 proceedings. We say she should point to any of the previous Article 146 proceedings in which the respondents were allowed to participate in the proceedings with their spouses and other members of the family. That has always been the law. I say, my ministers also complaining, say, Woko committee name no ya mani kunu ama metina hobi se wo answer question no nanke onanko nunya ya nanka ni kunu ntina hobi nanka ni what ya say question na wo answer no nanka ni kunu no say Article 146 omo troye no omo anka say oye Chief Justice oye hwan na ho asemba ne ye ka yampene soma wo kunu ana wo yere ana obi mra megina ho mra yesi wo pani ye hia wo Any bema watena ho. Yema mikunu. Any say from mikunu yebeka say the yema webusu apenyi yema wo hene yema. Any say nanka. Meshra mo mfa nchame. Ya hene ye ya. Ya hene ye ya. Yebeya ne say vetting. Vetting e ya no mo ya wo mo de ahemfo ne nkrofo ni na babegu wo no. Ya hene ya yebeya ne say vetting. Na mo de ahemfo ne sa nkrofo ni na babegu wo. Because basically that's what you are telling us. I say 7. She said the hearings take place in a cordoned high security zone on Castle Drive, Osu, when all Article 146 proceedings since 1993 had been held in a judicial facility at the Judicial Service, Accra. We say that the Chief Justice not know that all those other Article 146 proceedings were conducted under her auspices, but that this one is not. Now, I understand the point she's making. Sorry, I understand the point Tidosori has made. And let me explain so people understand. I say Chief Justice, no, suspended Chief Justice, no raise the issue, say, baby, I acquire or no vetting, no, high security zone. Now, so all the other Article 146 a year committee, sorry, and the vetting, probing. Now, so all the other 146 Article all the other Article 146 proceedings are akosono. Ye kwakoye no ewo courts. And obisa say unim say all the other ones no they were under your auspices and let me explain so you understand. One say let's go back in order for me to explain. Let's go back to Article 140 because this point is very 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 important, right? Very important. And what's what you say now? See what is going on here. Now all the other Article 146 proceedings no, see what the law says. Or say a justice of the Superior Court, original tribunal shall not be removed from office except for stated misbehavior. Or say a justice of the Superior Court of Judicature or a chairman of regional tribunal may not be removed in accordance with the blah blah blah. Or say if the president receives a petition now, if the president receives a petition for the removal of the justice of a superior court, other than the chief justice, or for the removal of the chairman of the regional tribunal, he shall refer the petition to the chief justice. Inti way na title sorry say all the other ones now will say a course or court. No and course will security special security side no. As someone can say because all the other ones no they were under you. And that is what Article 146.3 is saying. So what person who you judge you will be a and no your petition president na president they are share chief justice no answer na chief justice no una why we decide you no. It is all the other ones no na share wo wonsa. Inti anu no baby a wo be decide say yenye wo no ehon ne ye wo. Inti wo decide say yenye wo court. Ene ye wo court. Now so one kasa wasem na ye di no ensha wo wonsa ehye president ne nsa. Inti baby a president ne be decide ne ye be ye wo. What the Tadosori walk no what you say? Inti enda wo be yusu de aye complain. Say all the other ones no ye wo court den na menkwa me de ye wo security zone. Other ones na ehye wonsa. We ye ensha wonsa. Inti yentumi nkonko ye wo baby a wo pe. Ana baby a wo na ehye wonsa no ye wo no yentumi nkonko ye wo ho. Ase obi aye na ye tifie nkola what you say? Nkola ne we obia akola di boni a wo sane a wo treat no. Se wo papa na wo fie no nso di boni a ntumi nka se akola ne treatment ne de be ma wo papa no. What you say? Aha. Nti e no ene ye ka. O say number 8. Oh, the Chief Justice equates the Article 146 proceedings with judicial proceedings in the Court of Justice. We say that our Chief Justice does not even know the Article 146 proceedings are inquisitory and not in the nature of judicial proceedings, and that the committee is not a court of law. Into say Article 146 proceedings no Chief Justice no equate no to the judicial proceedings in the Court of Justice. Just say in some way course or court no Chief Justice in ya na nkasa na enkoso nso e wo committee na se. Ena tado sorry eka say oh the Chief Justice na who nim say sa committee no just probing inquisitory ye inquire akwa is a committee of inquiry. Ye de asem aba beto so ye hwem say asem ne ye nokware anase nye nokware. Inti nyama yakoso wo court no court de wo di wasem ono ohwese eye nokware enye nokware a wo ma judgment ba ha say no ye hwemu ye ntumi ma judgment ye ma judgment ye be ma recommendation ye ma judgment it is okay say court no ebia ye nante sie ne ye court no say ne ye ya de nti waba committee na ni a wonye ne se ne ye no court na da bi committee no onye court ontumi nye no se ne court de enete. Number 9. I say the Chief Justice has not been given copies of the petitions. She says, we say, what did she respond to that resulted in the prima facie answer? We've read that. Number 10, I say, most embarrassingly, the Chief Justice says the petition should have been put in evidence in the proceedings before the committee. Lord have mercy. We say even in the court, no party puts their pleadings in evidence in order for a trial to be validly conducted based on the pleadings. Also, Chief Justice Nasema was also kind of say, nanka petition ne krano, nanka they should be put in evidence. Ewa committee nenim. Inti petitions na ye raise yetiano no. Yamfa eno kran share evidence mu. Ewa committee ne no ka say na sa ade we e wo court kra no yenye saa even in court yenfa we say in court no party puts their pleadings even in court no ye pleadings yenfa nka evidence so e wo court nti de ntia ene yenye si e wo committee. Also, the Chief Justice says that the proceedings should have followed the Commissions of Inquiry, Practice and Procedure Rules, 2010, CI 65. And we say, so the Chief Justice, after laying hands on this statute, did not read the definition section, which specifies the type of committees to which the statute applies. And we ask, does the Chief Justice not know that in the Gertrude case, Sophia Ekufu, JSC, as she then was, held that the Article 146 committee is an ad hoc committee and is free to determine its procedure. The Chief Justice ne say, committee no, na common follow procedure bia wono esusu say na nka commission of inquiry e follow. And ono ka say, itu nim say emra wo ho, former Chief Justice Sophia Ekufu eruli ya waka say, committee one Article 146 committee a ad hoc committee. Na ad hoc committee biano. Omo committee no ene ebe determine procedure wo mo be yusu. Into untumi ma metro mo procedure wo mo yusu. 12. The Chief Justice says she expected that the petitioners must have a direct interest in the specific allegations brought against her in order to validly proceed under Article 146. The Chief Justice then someone can say, Omo wo raise allegations directly no, they don't have any interest. Into waba eba the petition say ane me so nti no bi ewu say ni ba kro na me so na we wu no oye we busu ani. What's your interest in it? Waba wo be ka say ane me metu kwan na kwan to a me metu no eni kwan say metu sa kwan no ana makwa ko yusu sika bi eni kwan say me yusu sika na me yusu na ye usika. Basically Chief Justice nsem a wo kan no, you don't have a direct link to nsem a wo say me ma ye no. Die ntia na wo raise allegations against me. Ena lawyer Tado sorry asem a wo kan ni. O say we say one, does the Chief Justice remember that in Charlotte Osei's case some of the petitioners were dead. So bisa say Chief Justice okay say Charlotte Osei case na eba ye no na petitioners ni bi kra no mo ewu no mo ntia ase no mo kro mo ewu omo anom ye petitioners ye see against Charlotte Osei ye ko check no mo din no kra bi mo ewu na so still ye use tia Charlotte Osei. 2, does she remember that Charlotte Osei was removed for procurement breaches? Okay, say Charlotte Osei ye know because of procurement ana say be procurement a procure no omo ana omo petition no, was they having a direct impact on them? Was they having a direct impact on them? I say, and if a Chief Justice does not even know that the Edetrum case said that in proceedings for the removal of the Chief Justice, no local standing is necessary, should we trust that she is the person to protect our democracy? I say, even in Ghana, ha emra a what say ye person you obi to say a Chief Justice. Any kwan say ka say ebia wa ye bibi etia me person tia na ye no dabi. Eye oman no ye dia. Into wodi bone no eye me e kame anka me kra na. Still e wo see etumi yi no. Any kwan say bone no nipa kra bone ne canons na say nipa ko ni mum na wo say oba be ma petition dabi. Into waka say Chief Justice moa. So wo nim bibi say ya. Into wo say fata say na ke wo say ye Chief Justice ana. Me say goes back to the point I was making yesterday. Me tie no. I'm always going to say this. As far as this case is going on, me tie no. Asemo me kind say, how did she become a Chief Justice? And today, you see what Tadosori is saying. The 13th point, or say if there is any takeaway from the sanctimonious political posturing of our Chief Justice in her statements, her depth in basic legal principles, candor in applying them, and fidelity to the law must leave us wondering if it is she, or say if it is she who must be trusted to spearhead justices in our democracy. Or say adie we nina akoso nina no. Say e wo bibia Ghana fo besua bibia free mu a. And I say, Ghana for question was say bisan say, inti nipa we ni pese onani Chief Justice. Nipa we na Ghana mra ye pese o hweso. Because clearly no, why exhibit say ono kra no wonte Ghana mra na say. I say, my lady honorable, your suggestion that without you there can be no justice is betrayed by the statement. So onu di woni wa embra entumi nye adwuma wo Ghana. I say, na say ma wo kan ye de ma me. I say, u peja ho dodo say wo de wu ni ho ambra bia entumi nye adwuma wo Ghana. Anyway, what about your comment box ni mo? Where I say